Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for spending your Sunday evening with us. The way this is set up for the next half hour, we've got a panel of experts ready to take your questions to deal with a specific subject matter. The way that you can take advantage of that opportunity is to call, text, email to join our conversation. Also a reminder, as is always the case, right now there are attorneys standing by. So if you call that number, you have the opportunity tonight to speak with a lawyer. So this is a great chance for you to get some free legal advice and join in on what we hope is going to be an insightful conversation. Leading our conversation from the firm of Hollis, Wright, Carter Clay. Good to see you, sir.
Good to see you, David. We're going to be talking about landlord and tenant laws this evening. About 1/3 of adults in Alabama right now are involved in a rental agreement, and they rent the place where they live. So this is an area and a topic that is relevant to a lot of people out there. And throughout the show, we're also going to weave in a little bit about home ownership and mortgages, because there's been a very important change in the law that recently took effect. But the primary focus tonight will be on talking about landlord and tenant laws. If you're a landlord, this is the show for you to learn how to protect your interest and your rights and preserve those rights. And if you're a tenant, we're going to talk about what you need to do to make sure that you're complying with the lease agreements and those types of things, so that the lease agreement goes smoothly and that you don't have any problems with the landlord. And if you do, what you need to do in order to protect yourself. So that's what we're going to be doing here this evening. We are very fortunate to have a great young attorney. I'll still call you a young attorney, even though you've been practicing many years now. Matt Wright primarily practices in Jefferson County.
Correct.
You're based out of Trussville. We really appreciate you being here. I know you're going to provide us with a lot of information on this particular topic here this evening.
Absolutely. Humbled to be here, and thanks for the opportunity.
Sure. Matt, tell us a little bit about your legal practice and how you got involved in handling cases associated with landlord and tenant laws.
Well, I have a practice out in, as you said, out in Trussville, and it's a true general practice. We do a lot of different things. There's a lot of different areas that we work with. And just by being in the general practice area, we get a lot of calls about general legal advice about leases, and landlords asking about tenants that they need to evict, or tenants who feel they're being wrongly evicted. All of that comes into play. And of course, just in meeting people from day to day, they know that I'm a lawyer and have a general practice, so they'll refer those kinds of questions to me.
So when the situation arises where a landlord has a problem with a tenant or vice versa, do you have a combination of representing landlords sometimes and tenants sometimes as well?
Yes, that's a pretty accurate representation. The majority of the time, it tends to be the landlords that come to see me as opposed to the tenants themselves. I do get calls from tenants, and I do help tenants if they need help, need representation. But the majority of it ends up being landlords who have a tenant who hasn't paid, or they have a situation where they don't know what to do with a tenant who's there or who has left property, or any number of factors that you can imagine if somebody's renting a home or an apartment or just a piece of land.
And what we're essentially talking about here when we talk about landlord and tenant relationships, we're talking about a relationship between an individual who is renting a place to live from some entity or some other individual.
That's correct. That's pretty correct.
And are there laws in Alabama that kind of govern or regulate that kind of relationship to protect the tenant, protect the landlord, and sort of establish some rights and obligations between those two parties?
There are. In 2007, there was actually a new law that was put into place, and it was called the Alabama Landlord Tenant Act. And it changed a lot of the way many leases have to be written. It changed a lot of the provisions that are allowed in leases nowadays. One of those are some of the things that a landlord can and cannot do to you while you are in the property. There are some old common law principles that are always going to apply, but these landlord tenant laws tend to help in situations where there may not be a written lease, and that's very common for someone to move in and they either never get around to it, never sign it, or the landlord just doesn't use them. It's a very common practice in Alabama, unbelievably.
And I imagine that the statutory law was created based on either the common law not addressing many situations, or there being so many causes of action or cases being brought in court that somebody at the legislature realized we may need to sort of codify this or put it into a statute statute and kind of lay it all out.
It did, and it set some ground rules for leases and some ground rules for the tenants and the landlords themselves. And it does. It protects the landlords and the tenants themselves, if as long as they follow it. Obviously, if they step outside those protections, they're kind of taking a little bit of a risk there. But yeah, that's exactly why it was put in there, because it was a situation where there just wasn't a lot of codified law that had been put into place to protect everybody, and they just needed it. It had been needed for a while.
What are you seeing in your practice right now? What are some of the more prevalent issues or problems that either landlords are facing or tenants are facing in that relationship?
In today's environment, obviously we've come through a time of when the economy has gone down, and there have been a large number of people who've shifted over from home ownership to renting a house or renting a home because they just don't have any other alternative. And in today's environment, that has sort of boosted the amount of people who are renting houses or renting a trailer or renting an apartment building, something of that nature. And the entire realm of that it's expanded. It's gotten larger as far as what you deal with from a landlord-tenant side. And the majority of the problems that I see almost all the time, not every time, but a lot of the time, are where a tenant has stopped paying, or vice versa. On the other side of that, a landlord won't accept the payment, which creates an entirely different set of problems in that realm. So you run into a lot of different things, but generally, as the economy turns down and mortgage approvals or mortgage disapprovals go up, where people can't buy a home, they have to rent. They obviously have to have somewhere to live. And so if you can't buy the home, you'll go rent a house, or you'll go rent something in the neighborhood that you possibly might buy in the future, so that you can get a feel of it.
All right, I have to ask you this. Give me an example. Why would a landlord not accept payment from a tenant?
Well, I've run into those situations. That is where the landlord may have an opportunity to rent the house or the home for a higher rent basis, yet there's a lease in place that prohibits them from doing that. And so one of the only ways that they can get you out of the property is to stop taking payments. And that's a very good way of removing somebody from the property.
Good conversation. We're off and rolling. We'll pick up right there whenever we come back as we step aside. A reminder of how you can join our conversation here on The Attorneys tonight. You can call, text, email. You can also find the firm of Hollis Wright. If you'll search that term, Hollis Wright, you'll find them on Facebook. And on Twitter, it is Hollis_Wright. So plenty of ways for you to get in touch with us here at the show and also keep up with the firm of Hollis & Wright. One segment in the books, more of The Attorneys straight ahead. Stay with us.
I'm Carter Clay with the law firm of Hollis Wright. Thanks for watching The Attorneys on WVTM 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the Attorneys link. Now, we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.
Landlord and tenant law, the topic of conversation tonight on The Attorneys. It's always better when you join the conversation. Ways that you can do that is to call, text, email that information at the bottom of the screen all throughout the program tonight. I got a question tonight. I got someone who is apartment shopping. They said that they're currently doing that, looking for an apartment. What advice can you give me prior to signing a lease?
Probably the single largest piece of advice, if you don't have any other takeaways from this entire program, is to get a signed written lease agreement and
Okay.
review it before you sign it.
Is that not commonplace, or are there some places?
It's fairly uncommon. I probably see 50% of cases where there is no written agreement in place at all. Maybe even more than that. I'm just referring
Right.
from memory, of course, but it's very, very common. There's something I tell clients is that everything goes right as long as it goes right.
Right.
And one of the situations you run into is where the relationship breaks down. And so if you know someone or you have a trusted friend that you, or an acquaintance that you would trust to rent a place from, reduce that to writing. That's the best single thing you can do to protect yourself and to protect the landlord in case something comes up. And it's very common that somebody just trusts somebody and it kind of goes off the rails, so to speak, and there's no other way to repair that except to go to court if the parties can't come to an agreement.
Yeah, and I would think one other real important thing that a tenant would want to do is to obviously fully and thoroughly inspect the premises before you enter into the lease agreement and agree to go in and live there.
Absolutely.
Because the last thing you want to do is move in and then you have problems that were there before you moved in, but then the landlord tries to tax you with the cost of making a repair. So you really want to go through, check the air conditioning, the heat, check the dishwasher, the washer dryer, whatever the case may be. Make sure if there are any marks on the wall that those are identified and marked and pointed out to the landlord. That way there's a clear understanding of what problems existed at the time they moved in.
And that's the point where the tenant will probably have the most leverage, going into the agreement. I mean, at that point, it is what it is.
And in today's world, I mean, we all carry cell phones that have cameras. I tell everybody, click as many pictures as you can. Storage is cheap. Even if you put it on a thumb drive or burn it onto a disk, and just put it away with your lease agreement, or print the pictures out. Do the old-fashioned way, just print them out and throw them in a file. That is one of the things that will help more than anything. And if you do run into something where a landlord says, well, the toilet was working fine when you moved in, you can go back to that and say, well, look, here's the marks. Here's where an invoice where somebody came out and inspected this before we leased it. How could it have been working? How could it have repaired itself in the time being? But yes, that's very important to document that, check everything, make sure everything's working, and get what you're expecting to get. So to speak.
Yeah, certainly, Matt, there are a lot of landlords out there that are just individual homeowners that are renting out their particular house for rental income and those types of things. But a lot of the apartment complexes and condos and things like that are owned by entities, companies, corporations. And I saw a lease agreement the other day that was actually 17 pages long.
That's not
so
uncommon.
when you have a corporation that's a landlord, they're going to have lawyers like us that are drafting these things. And as a lawyer, you're trying to protect your client, so you want to throw everything in but the kitchen sink in a lease agreement to protect the landlord. So the question I have is, under the Landlord-Tenant Act in Alabama, is a landlord free to just put one-sided protective provisions in there that protect the landlord, or is there anything they can't insert?
No, there are a number of things that they can't insert. One of those is that you cannot make a tenant responsible for attorney's fees and collection costs if they don't pay their rent. That's one of the major changes that we've seen. The landlord can't absolve themselves from what they call liability. In other words, if you get injured on the premises for something they're supposed to do, or if the landlord says that he can essentially do anything wrong, that is a prohibited agreement in the lease language. You can't have that. It's just not allowed by the new Landlord-Tenant Act laws. And that really helps tenants to protect themselves within the agreements there. And if you see that, I would think very seriously about moving on to maybe finding another place to live or another landlord to talk to. And if you have a corporate structured entity like that, sometimes their lease agreements are basically non-negotiable. They'll tell you that they don't have to change any of the provisions of that lease, which is very common. And most of their leases are what we would call pretty middle of the road. You generally won't have those kinds of things. But there are sometimes when you get something that it may throw a red flag up, go see a lawyer. Just go make an appointment with a lawyer and spend 30 minutes with them. Have them read over the lease, and that's the best way to protect yourself.
Now, when we talk about a dwelling being livable or habitable, what are we talking about, and are there any factors that a tenant can look at to make a determination as to whether or not a dwelling is habitable? I mean, I know common sense would be a good thing to apply there, but I think that's really important because there are a lot of condominiums and apartments and houses out there that are dilapidated and in poor condition. And so the question becomes, is it a livable environment?
That goes to, like you said, common sense. Now, the Landlord-Tenant Act spells out some things. The landlord has to provide water and heat and air conditioning. They normally have to provide a structure that is sound and safe. In other words, if one of the things that we do run into is someone who wants to rent a place, and they will rent something not knowing what is there and not understanding what they're renting. That is a very large part of some of the problems we run into with residential landlord. They will sign a commercial lease and they will think that the livable conditions provisions that are in residential leases apply to a commercial lease, and lo and behold, they don't. So that's a huge difference. But yes, common sense things, running water, plumbing, restroom facilities, things of that you would normally want to have a sufficient amount of space that you would need to live.
A question we have here: I've complained to my landlord about needed repairs. He's now threatened to raise my rent. Can he do this?
Generally, no. The first question or the first answer that you'll generally hear from a lawyer is it depends. But right. No, the Landlord-Tenant Act says that no, he can if there is a lease agreement in place. Now, what that does not prevent, back to not having a lease agreement in place, what that does not prevent a landlord from doing is if you are a month-to-month renter and you don't have a written lease agreement, the landlord has every right to terminate that lease in 30 days. He could say, well, thank you for notifying me for the repairs, but I'm terminating this lease in the next 30 days. And if you don't have a written lease agreement that says you can be there for 2 years or 4 years or 6 months or whatever the lease term may be, then he has every right to do that. But no, he cannot raise the rent on you during the term that you're there. Right. That would be a new term or a new lease that would have to be negotiated. He can't break the lease agreement, in other words, to raise that rent. No.
Right. And I know we're about to take a break. When we come back, we want to talk about what a tenant's rights are in the event that the landlord does not make repairs and make them sufficiently or in a timely manner.
Good deal. We'll pick up right there. We'll step aside. This is our final break of the evening. Just time enough to remind you, if you'd like to join our conversation for the final segment, call, text, email. Would love to have you chat with us and let us know what's on your mind. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright. If you've ever served on a jury, you may have wondered why there are gaps in the evidence you're given at trial. In today's Legal 4-in-1, we're answering the question, is there insurance to pay the verdict? Know this, just because the lawyers never mention insurance in a trial, it doesn't mean there's not insurance to pay the verdict. Rule 4-in-1 of the Alabama Rules of Evidence states this: evidence that a person was or was not insured against liability is generally not admissible or allowed to be discussed at trial in front of the jury. The reason for the rule is simple. A jury could award more money in a case if they knew the defendant had insurance to pay for it. But the reality in our state is this: in almost all lawsuits that get to a trial, insurance is there to pay judgments awarded by the jury. For example, all automobiles in Alabama are required to have liability insurance. Coverage can range from $25,000 up to $1 million in these cases. In theory, all car crash cases that get to trial should have insurance available to pay any verdict awarded in the case. Trucks have to carry anywhere from $750,000 to $5 million worth of insurance. Unfortunately, you'll never hear that during the trial. Even in medical malpractice cases, the doctor has liability insurance to help pay a judgment. That's something you won't hear during trial because the rules just don't allow that testimony. Yet almost all judgments against a doctor involve liability insurance. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our promise and pledge to you.
Welcome back into the attorneys trying to get a handle tonight on landlord and tenant laws. We appreciate so much you being with us. A reminder, at the bottom of the screen, you'll find ways you can call, text, email. That's how you get in touch with us. Just a few minutes remaining, so if you have a question, go ahead and get it on into us. Carter?
Yeah, Matt, let's talk for a minute about what a tenant should do. They've got some problems in the house that they are renting. Perhaps the plumbing is bad, water's not good, or it's not running properly. There are repairs that need to be made. The tenant puts the landlord on notice of those problems inside the apartment, and they're not really getting much of a response from the landlord. He's not coming in and making the necessary repairs. What are the tenant's rights at that point, and what do you recommend the tenant should do?
Well, the first thing that we would do is back to the lease. The first thing we're going to do is look to the lease agreement. Your lease agreement is going to tell you everything you need to know about that. But document. As I said from the start, get a written lease and then document every problem you've got and get that to the landlord. If you get that to the landlord, they have a 14-day, by default, a 14-day time to respond and make the repairs. So if they make the repairs within that 14-day time limit, then everything should be okay in theory. Now, your lease may give them a period of time that is shorter than that. They may say it only gives the landlord 48 hours, or it may be for something, if it's something that's dangerous, like a gas leak or something, you probably need to call the fire department and notify your landlord. But always notify the landlord in writing and tell them that if you don't hear back from them in 14 days, unless the lease provision says something different, that you're going to have to take actions either to protect yourself or to move out.
All right, and so let's take that 14-day time period. The landlord does not make the repairs or does not have proper repairs made. What does the tenant do, or what are the tenant's rights at that point? Can they stop paying their rent? Can they just pack up their stuff and move out? What should they do at that point?
The safest, absolutely the safest thing to do is after 14 days, if it's something that is critical to the livability of the home. Now, we're not talking about something like a blown out light bulb or a scratch on the wall. We're talking about something where the toilet is not working, an electrical surface is shorting out, something of that nature. The safest thing to do is to notify your landlord in writing and use the mail. Don't send a text message. Don't call them. Send something in writing that's provable that you can offer to a court of law and say, look, I mailed this. Here's the U.S. mailing and the return receipt. Always try to use certified mail and return receipt so you'll have proof that you've sent it. But then, yes, the only alternative sometimes is to move out. Always refer back to the lease agreement, of course, but if you move out, the safest thing to do is, again, notify the landlord. I notified you on day 1. This is day 15. I haven't heard back from you. I've got no choice but to move out, and then continue to document that even after you're gone.
Yeah, and documentation is such a key point here, David, because what you don't want to have happen is everything that Matt just described may very well have happened, but if it was all based on oral conversations and then you move out and the landlord sues you for not paying your rent for the leasing agreement, then you just don't have the proof that you need to be able to establish that you were justified and right in moving out when you did.
Very common.
You know, let's flip the script a bit. We're talking there about the tenant and the tenant's right. What about the landlord? If I know a lot of folks, probably a lot of folks listening, rent out places and find themselves in that position. Well, what if a tenant is not paying or refuses to pay? What sort of rights does the landlord have?
The landlord has a couple of options. The first option is, of course, we would look back to the lease agreement. Like I said, I know I sound like a broken record saying that, but that's the test is the lease agreement. If there is no lease agreement in place that tells us what to do, the only thing that you can do is provide, number one, you have to provide them a written notice. The minimum the law requires as of today in 2016 is a 7-day written notice. In other words, they have to notify you, get you a notice that says your rent has not been paid. You have 7 days to pay it. If you don't pay it, they have every right to terminate the lease and begin the eviction process. Now, if you tender the back rent and any rent that is due during that 7-day process, it sort of redeems you, so to speak. But now your lease agreement may say you have a period of 30 days or 15 days or 20 days. They're all over the board, but generally they're around 30 days. But remember that the law only requires them to give you a 7-day period in which to pay it in full. Now the landlord, if the landlord does not provide a written notice of the default of at least 7 days, then any further action is not valid under the court.
Well, during my legal career, I've heard of instances where somebody would call up and say, well, the landlord said that I didn't pay on time, and they got all my stuff and they threw it out, or they packed it up and put it outside the house and they changed the locks. Can a landlord do that?
No. The eviction process in Alabama does not allow what's known as self-help. If the landlord gets involved of their own volition without taking court action, without the order from a judge, essentially is what it is, they have some pretty good liability within the landlord-tenant law. And there may be something set out in the lease that dictates that also. The only time that a landlord is allowed to move things out of a house is if someone has been missing for a period that exceeds 14 days and they have provided written notice that it's been more than 14 days, I don't know where you are, I think you've abandoned the place. And then there's another 14-day period where you would want to secure any property and try to get in touch with the person and say, I'm holding and safeguarding your property for another 14 days. And then at that point, there's not really a whole lot more the landlord can do.
If they get that eviction notice or eviction order from the judge, would the proper step by a landlord at that point to be to elicit the help of the sheriff's department?
Yes.
And would the sheriff's department then come out and oversee the moving out of the personal property of the tenant?
That is exactly correct. If you're a landlord and you own property, the first thing you want to do is get a lawyer involved as soon as you can, because lawyers that deal with this know how to protect you and they know how to help you. But the landlord would need to deliver a written notice. If there's no response after 7 days, then you could move forward with filing what's called an unlawful detainer. The unlawful detainer action would allow you to move forward with the eviction process, and once a judgment is entered, then you would file what's called a writ of execution to have the sheriff's office come out and actually remove the property. So yes, you want to have the courts involved at every step.
It's hard to believe that we're almost out of time, isn't it?
Yeah, it's flown by.
We've covered a lot of ground here. I want to give both of you an opportunity for a final thought, and Matt, we'll start with you.
Well, the single greatest thing I can tell you to do is put your leases in writing. And if you don't put it in writing, at least document everything you can through either trackable emails or something that is written down like a text message, worst case scenario. I never ever suggest doing anything over the phone or verbally. Although it's valid, although it's a very valid way to conduct business, if you are leasing a place and you want to know the terms, write it down. It's a piece of paper that it is an extra step. It takes a couple extra minutes, and it may even seem old-fashioned to some younger people who we deal with because they do everything electronically. But even if that's the case, write it down.
Write it down.
I just want to give one more piece of advice that we weren't able to cover throughout the show, and that is a renter's insurance. I think this is critically important that a lot of people overlook and don't purchase. When you're a homeowner, you have homeowner's insurance. So the aspect of homeowner's insurance to some extent will protect your personal property. But if you are a renter, then you're not going to have homeowner's insurance.
Right.
You have to have renter's insurance to protect your personal property, so that if you say you're cooking and a fire starts in your kitchen and your personal property burns up, the only way to get compensation for that is through renter's insurance. So I would highly encourage everybody to take a look at that who's out there renting if you don't have renter's insurance.
Really helpful information, gentlemen. Thanks so much. Matt, Carter, appreciate the time. Also appreciate you being with us tonight. As we wrap things up, here's how you can get in touch with the firm of Hollis Wright. Also find them on Facebook as well as Twitter. We appreciate the time as always, and we'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.